safest thing is just to record it and then get the video and the audio off later. But it does say custom live streaming, doesn't it? Okay, it saves live now, so it looks like he's got it up. Yeah, he's got it up. Fine. Let's go with that. Kevin knows what he's doing.
Thanks, Marlene.
Okay, sorry about that.
No bother. So thanks everyone. I mean, there's certainly been a big demand, as you can imagine, for this meeting. We knew it was topical when we arranged it, but we didn't realise it was going to be quite as topical, because we thought it was going to be a bit longer till we got the Supreme Court judgment. We were expecting January, so hopefully a good number of you were at demos last night. I was certainly at the one at Buchanan Street, so there was a good turnout for that, and folks seem up for getting involved and ramping up the campaign. So thanks everyone for coming along. Aileen McHarg was good enough to do face-to-face public meeting for Yes Southside.
Pardon? I'll put the piece on now, actually.
Right, sorry, I'm just getting a bit of feedback here, so I'm going to have to mute a few folk, I think. Right, so anyway, so Aileen McHarg is a professor of public law at Durham University, and she's a renowned expert in the Constitution. And if any of you follow Aileen on Twitter, you might see she's locks horns with Adam Tompkins quite regularly, and gives him the proper down on things when he gets a wee bit carried away with himself on the Constitution. So as I was saying, Aileen had come along to a Yes Southside face-to-face public meeting just before COVID, actually, and it went very well, but things have moved on since then. So we invited her to give us her perspective on the Supreme Court judgment, which we now know what it is, of course, what the outcomes of that, the consequences of that will be for us, and what opportunities we may be able to pursue. So can I just pass you over to you, Aileen? You can go on with things, hopefully. So Aileen's going to do a talk, and then we'll open it up to question and answers. You'll see there's you'll see the reactions for raising hands if you want to ask a question, and Jane will be supervising the question and answer session. Okay, thanks very much.
Okay, thanks very much for inviting me, Malcolm. I'm very happy to be here. As you said, this did turn out to be unexpectedly good timing, although in general for me this week it was not good timing because I was very, very busy yesterday, but we are where we are. I'm going to try and cover two sets of issues. I'll spend a little while talking about the case itself. I'm just going to sort of recap on how and why the case came about, what the issues were, how they were decided and why they were decided the way they were. And then I'll talk about the potential implications of the decision in terms of the constitutional pathway or pathways to independence. And please bear in mind that I talk to you as a lawyer. I'm not a political scientist, I'm not a political pundit. And that's important because the key effect of this decision is, at least in the immediate future, to throw the question of how Scotland becomes independent back into the political realm. So, to focus on the case, to remind you, the case arose essentially because under the Scotland Act, in order to introduce a bill into the Scottish Parliament, the person who's in charge of the bill has to state that, in their view, the provisions of the bill would be within the Parliament's legislative competence. So that's known as a competence statement, a competence certificate, and it's an absolute requirement. If the person in charge of the bill cannot state that the bill is within competence, it simply cannot proceed. So it's an absolute barrier to introducing a bill into the Parliament. Now, in some cases, this question of whether or not a bill is within competence will be pretty straightforward. It will be obvious that it is or it isn't. But in other cases, because the boundaries of the bill of competence are complex and increasingly complex, and in some cases, the precise limits may be uncertain or unclear, that means that a legal judgment has to be made about whether or not the bill would be more likely than not to be found within competence if it were to be challenged at some point. Okay, so a kind of legal risk judgment has to be made. Now, because of that, because this involves a legal judgment under the Scottish Ministerial Code, which is a non-statutory code but very, very important. In the case of government bills, ministers have to get the clearance of the Scottish law officers before issuing a competence statement. So in the case of the referendum bill, the Lord Advocate, this is Dorothy Bain, KC, she stated after lengthy internal discussions, she stated that she didn't have the necessary degree of confidence that the bill was within competence in order to allow her to clear the competence statement for the bill. And it's likely that her predecessor, James Wolfe, had the same view because, as you probably know, the bill had been promised for really quite some time, going right back before the last election. But, you know, it never appeared. It was always imminent and it never appeared. And it seems likely that that was the key reason. The specific reason for doubting the competence of a referendum bill was whether an advisory referendum on independence, so in other words, one which provided for a vote to be held but didn't specify any legal consequences that would flow from the outcome of the vote, whether that advisory referendum would nevertheless relate to the Union and the powers of the UK Parliament, both of which are reserved matters under the Scotland Act, and therefore matters in relation to which Holyrood is not allowed to legislate. Now, the competence of such a bill was not completely clear-cut because the issue wasn't explicitly addressed in the Scotland Act. The Scotland Act did not explicitly address whether an independence referendum would fall within these two reservations, except for a short period, except when prior to the 2014 referendum, there was the Section 30 order, which temporarily amended the Scotland Act to clarify that an independence referendum was not within competence. And that was a temporary amendment and it was repealed by the Scotland Act 2016. So we went back to the status quo ante 2014, that the Scotland Act just didn't address the issue. So not clear cut, and it was an issue that had been a matter of controversy going right back to the time that the Scotland Bill was being debated in the Westminster Parliament in 1998. If you look at the parliamentary debates on the bill, there's actually quite a lot of discussion about whether or not Holyrood would be able to hold an independence referendum. And then there was lots of academic debate as well. So although the Lord Advocate didn't have the necessary degree of confidence that the bill, if challenged, would be held to be within competence, she did recognise that this was not a clear-cut issue, and therefore she agreed to the First Minister's request to make a reference to the Supreme Court in order to get the matter settled. Now, that reference was made back in June, and the Lord Advocate in her reference didn't argue straightforwardly one way or the other that it was either within competence or out with competence. Rather, what she did was to set out the arguments on both sides of the debate, and she invited the court to rule on which view was correct. Now, that was a substantive issue that she asked the court to decide, but there was a complication, which was that the power she used to refer this question to the court. It was a reference power under the Scotland Act, but it was a reference power that had never been used before, certainly not in Scotland. There had been a couple of references from Northern Ireland, both of which had been rejected by the Supreme Court. So this was a kind of obscure power. It was a power to refer what the Act refers to as devolution issues in circumstances where there was a legal issue to be resolved. It wasn't the subject of any other case currently before the courts. Devolution issues are defined in the Scotland Act to include a range of specific issues, and then the list of definitions ends with a general provision which says devolution issues include any other question arising by virtue of this Act about reserved matters. And it was this general provision that the Lord Advocate was relying on. She said the question she was referring to the court was an issue about reserved matters. Now, the Advocate General for Scotland, who is the UK government's advisor on Scots law, responded to this reference in 2 ways. Firstly, and wholly unsurprisingly, he said, well, in his view, a referendum bill did relate to reserved matters and therefore was out of competence. You know, that not surprising, because that was the position that the UK government has consistently adopted since before the 2014 referendum. But secondly, he also argued that the reference procedure used by the Lord Advocate either didn't apply to this situation at all, or he said if it does apply, the Supreme Court should exercise its discretion to refuse to accept that reference. Now, his specific reason for arguing that was that the Scotland Act creates a specific procedure for referring the questions about the competence of bills to the Supreme Court. And this is a procedure which applies after the bill has been passed by the Parliament but before it's received royal assent. So you might remember the UN CRC incorporation bill was referred in that way a couple of years ago, as was the continuity bill back in 2018. So the Advocate General said, well, we have this specific power for referring bills, and so it would be inconsistent with the existence of that specific power to interpret this general power as allowing bills to be introduced prior to their being introduced into Parliament in the first place. So he said these would essentially be hypothetical questions, and the courts don't normally answer hypothetical questions. If you remember the Keatings case, the case brought by Martin Keatings a couple of years ago, he was trying to get the Scottish courts to rule on the competence of a referendum bill, and the Court of Session, both the Outer House and the Inner House, rejected.
Aileen, it's Jane. Sorry to interrupt you. It's just, could you just stay near the microphone, because it's kind of coming and going a wee bit. Sorry about that.
Okay, I'm not sure where my microphone is. It's inbuilt somewhere, but I'll try to.
Okay.
Okay, I'll try. Let me know if it's problematic.
Right, thanks.
Right.
It's good where you are just now, Aileen. So.
Okay, I'll try to stay here. Yeah, so the Court of Session rejected Keating's case on the basis that it was hypothetical and premature. So the Advocate General was saying, well, the same thing applies here. We don't actually have a bill. It hasn't been passed by the Parliament. It's premature. So there was that procedural issue to be decided. Had the reference been properly made by the Lord Advocate, as well as the substantive issue about whether or not a referendum bill was within competence. The Advocate General had asked initially the Supreme Court to decide the procedural question first and just kind of reject the case out of hand, but the Supreme Court decided that it would hear both points together, which it did so obviously in October. Now, the third complication was the fact that the SNP then made a separate intervention in the case, separate from the Lord Advocate, and the party put forward separate arguments for why they thought the referendum bill should be held to be within devolved competence, based primarily on the right to self-determination in international law. The SNP was only allowed to make a written intervention, and they weren't represented in the oral hearing in October. So, as Malcolm said, the decision was handed down yesterday morning, much quicker than had been expected, and much quicker than Lord Reid had led people to believe at the end of the October hearing. What he said yesterday was the speed of the decision was partly because it was unanimous, but partly because they'd actually given it priority over their other business, so they had actually expedited the case. The decision did address all of those three issues that I've outlined, so whether the reference had been properly made, whether a referendum bill relates to reserve matters, and whether Scotland has a right to self-determination in international law. And that was quite surprising that it addressed all three issues. A lot of legal commentators had argued that the reference should be rejected, that it wasn't competently made under the Scotland Act, and therefore they thought that the Supreme Court would not rule on the question whether the bill related to reserve matters. I wasn't wholly persuaded by those arguments, but having watched both days of the hearing, I was quite surprised that there was an unanimous decision to accept the reference, because some of the judges, at least, have seemed to me to be decidedly sceptical, whereas others seem to be much more receptive to the Lord Advocate's argument. So I was surprised that it was unanimous, but it was unanimous, and the reference was accepted. I had nevertheless thought that, well, even if they had decided that technically the reference had not been made properly, I did think that they would say something about the question about whether a bill related to reserve matters, whether they made a binding ruling as they did yesterday, or whether they just made what lawyers call an obiter comment, so it's something that's not technically binding but gives you an indication of what the court thinks. I thought they would give an opinion, because if they had rejected the reference, it is possible that the bill would have come back to them, or the question would have come back to them via some other route. So I thought that, having heard debate on it, having heard the arguments, they would want to just resolve it and not just postpone it to a later date. So I did think that they would decide that substantive question, and I did think that they would find that it fell out with devolved competence. And I say that notwithstanding that way back in 2012, I, along with colleagues, had published a blog post arguing against Adam Tompkins, arguing that there was a case for saying that it was within competence. But in the interim period, the way in which the court's devolution case law has gone, I thought it was much more likely than not that they would find that it related to a reserve matter. And that's of course what happened. I was a bit more surprised that they said anything at all about the SNP submissions on the right to self-determination, and that was for two reasons. Firstly, because the court doesn't always necessarily address the arguments made by interveners. Sometimes they'll just ignore them if they don't find them particularly helpful. But also because I think that what the court had to say about self-determination is probably the most politically sensitive part of the decision. And I thought that they might want to just steer clear of that if they could. But they did go ahead and decide the self-determination point. And of course, they rejected those arguments as well. So I'll try and go through each of these points in a bit more detail and try and explain why the court decided each of the issues in the way that they did. So the court's approach to the procedural issue, so whether the reference had been properly made, and its approach to the question whether a referendum bill relates to reserved matters, are actually very similar, and they're very similar in two ways. In the first place, the court's decision on both points was based on what is now its standard approach to interpreting the Scotland Act, which is to place most emphasis on the words that are used in the statute itself. But the court approaches devolution questions in the same way as it approaches any other question of statutory interpretation. It doesn't treat the devolution statutes as having sort of particular constitutional significance and therefore needing a different approach to interpretation. So it looks very much at the ordinary meaning of the words that are used in the statute. And the second thing that both of those parts of the decision have in common is that they reflect an understanding of the political importance of an independence referendum, even if it's just advisory, technically an advisory referendum. So in relation to the procedural issue, the court's starting point was that the words in the statute, and as I said, the words were any other question arising by virtue of this act in relation to reserved matters. The court said these words were wide enough to include the reference made by the Lord Advocate. The Advocate General had tried to argue that, well, actually these words should be given a narrower meaning because the various anomalies would arise if they didn't, and actually they were intended to mean something different. But the court was not persuaded by any of these arguments. They weren't persuaded that they were enough to displace that ordinary meaning of the words of the statute. And then in addition, the court accepted the Lord Advocate's argument that it was in the public interest to determine the question whether a referendum bill would be within competence at this point. They said this was no longer a hypothetical issue, it's a real question that the Lord Advocate had to answer, and it was a question of major public importance, major political importance, and so they accepted the reference for those reasons. So the Lord Advocate, that's a victory for the Scottish Government on that procedural point. However, the combination of those two factors, the approach to interpretation and the political importance of the referendum, produced a less favourable outcome on the question whether a referendum bill would relate to reserved matters. Now again, the court's focus was on the wording of the Scotland Act, and this says that the question whether a bill relates to reserved matters is to be determined by reference to the purpose of the bill, including its effects in all the circumstances. It's to be determined by reference to the purpose, including its effects in all the circumstances. And in previous cases, it had been held that in order to satisfy that test, a bill had to have more than a loose or consequential connection with a reserved matter. So the argument that the Lord Advocate presented for saying that a referendum bill was within Holyrood's competence was to say that, well, an advisory referendum, as I said, it would have no legal consequences beyond the organisation of the vote, and whatever practical consequences it had would be entirely speculative at this stage. We wouldn't know the outcome, we wouldn't know how anyone would react to that outcome. So they said, the Lord Advocate said, you focus on the legal effects, and the legal effects are nil. So they say, well, yeah, obviously this has got something to do with the reserved matter of the Union and the powers of the UK Parliament, but that is merely a loose and consequential connection, and it's not enough to take the bill out with competence. However, the court held that it was not confined to looking at the legal effects of the bill. So the statutory test was the effects in all the circumstances. The court says that means it's not just the legal effects, you can look at the practical effects as well. And it took the view that even an advisory referendum would be an event of major political importance. It wouldn't just be an opinion poll or a survey. It would be an authoritative expression of the democratic will of the Scottish people. And they said, irrespective of the result, whether that was for or against independence, a referendum would necessarily have major implications for the future of the Union and for the continuation of the sovereignty of the Westminster Parliament in Scotland. So it thought for that reason the bill clearly had more than a loose or consequential connection with reserved matters. So then finally, the court looks at the issue of self-determination. Now, on that point, the SNP had argued that if there was room to interpret the statutory test about whether or not bill relates to a reserved matter in different ways, then what the court ought to do is to read the statute in such a way as to uphold the right under international law to self-determination. So in other words, it should be read, if possible, to allow an independence referendum to take place. Now, the Supreme Court accepted the general principle that legislation should be interpreted in line with international law in cases of ambiguity. But first of all, they thought there was no real ambiguity here. They were satisfied about what the statutory test meant. But more fundamentally, they also rejected the claim that it would be incompatible with the right to self-determination if the Scottish Parliament could not unilaterally legislate for an independence referendum. So in other words, they didn't think that the principle of self-determination under international law fitted the case here. Now, why did they reach that decision? Well, they relied on a case decided in 1998 by the Supreme Court of Canada, a very famous case called the Quebec Secession Reference. In that case, the Canadian Supreme Court had held that the right to self-determination in international law was limited in scope. So that the court drew a distinction between the right to internal self-determination, so a right to be represented in or to take part in the decision-making processes within the state, and the right to external self-determination, which basically means the right to secede from the state and become independent. The Canadian court said that international law only gives rise to a right to external self-determination in limited circumstances. And these circumstances limited to situations where people cannot effectively exercise any internal self-determination. So the examples they give: colonized people, oppressed people such as those under foreign military occupation, or peoples denied any meaningful access to government within their current state. So because those groups of people had no meaningful internal self-determination, the right to self-determination would give them the right to secede, but not in other cases. So the right to self-determination does not mean that everybody can become independent. So the Canadian Supreme Court in the Quebec Secession Reference had said, well, the people of Quebec, this is a federal system, they have their own system of government, and they clearly don't fall into any of the categories that we've identified where there is a right to secede. And the UK Supreme Court said, well, the same thing applies to Scotland. The people of Scotland have internal self-determination and therefore are not entitled to external self-determination. In addition, and this is slightly more obscure this point. The UK Supreme Court held that the allocation of powers under the Scotland Act, as between the UK and Scottish Parliaments, could not infringe the right to self-determination. But what I think the court was saying there is that it wouldn't matter from an international law perspective whether the competence to legislate for an independence referendum was allocated to the UK Parliament or the Scottish Parliament. So even if there was a right to external self-determination, wouldn't necessarily have to lie with the Scottish Parliament, which might be a more controversial point. Now, the final point to stress about the judgment before I talk about the implications is really that the SNP submission was largely related to questions of international law, not domestic law, and the Supreme Court's judgment was wholly limited to international law. So there's a contrast here with the Canadian case. The Canadian Supreme Court, after considering the right to self-determination under international law, went on to consider whether under the Canadian Constitution, Quebec had a right to secede. But the UK Supreme Court's ruling yesterday did not say anything at all about whether Scotland might be regarded as having a right to self-determination under domestic law. And I'll come back to that point in a minute. Okay, so what are the potential implications of the decision? Well, first and most obviously, most immediately, it means that no referendum bill can be introduced into the Scottish Parliament unless and until the Scotland Act is amended. And since that seems very unlikely to happen, it means there won't be a referendum next October. Now, the Scotland Act could be amended in one of two ways, or two main ways. You could get another Section 30 order, as in 2014, to authorise a referendum on a one-off basis, or you could have a permanent amendment setting out the circumstances and the conditions under which referendums in general can be held. So that would be similar to the situation under the Northern Ireland Act, which regulates the holding of referendums on Irish unification. It sets out conditions under which referendums can be triggered and a minimum time period of 7 years between referendums. So we could have an ad hoc amendment, or we could have a more kind of permanent, more detailed regulation of the issue. But either way, it puts control over whether and if so when another referendum takes place into the control of the UK Parliament rather than the Scottish Parliament. Now that's not entirely bad news, because under the UK's wholly flexible constitution, and unlike some other constitutions, there's nothing legally or constitutionally to stop the UK Parliament agreeing to a referendum, to agreeing to amend the Scotland Act. It could happen, it obviously has happened, and it could happen again. The UK Parliament is free, if it wants to redraw the boundaries of the state on whatever conditions it wants. So that makes the achievement of independence primarily a political issue. It becomes a question of persuading the UK Parliament to legislate for it. And I think the second positive thing to take away from this is that there is abundant acceptance at the level of political principle that the Scottish people do have the right to become independent at some point. So the thing that's really struck me over the past few years, UK politicians, of course, have been saying repeatedly, no, you can't have a referendum. But that has always been justified in terms of timing. You can't have a referendum now for X, Y, and Z reasons. Apart from, on the fringes of unionism, there hasn't been any rejection of the principle that at some point, whatever that might be, at some point, it is possible for Scotland to become independent. Now, you can find plenty of political statements, political precedents to support this. And that's important. The UK constitution is not a wholly legal constitution. It is partly a political constitution. So political precedents and principles and statements do matter. Nevertheless, the UK constitution is, as things currently stand, entirely silent on the circumstances in which we can succeed or what the precise pathway towards secession might be. We're just in a situation of complete legal silence and political disagreement. Now, as that suggests, I don't think there's a plausible argument that can be made that as a matter of domestic constitutional law, Scotland has a legally enforceable right to become independent. I know there are a variety of arguments that have been put forward in this area, most recently arguments based around the claim of right. But in legal terms, these are very weak arguments, as well as historically highly contentious. And it's very, very unlikely, in my view, that you will ever persuade a court. In the contemporary constitutional order, the people of Scotland have a legal right to secede from the UK under domestic law. And in any case, they come nowhere near, even if these fragmentary legal principles and precedents mean anything, they don't come anywhere close to establishing a clearly set out pathway towards independence. So, as I said, the key effect of yesterday's decision is the pathway towards independence is firmly in the political sphere. It's entirely up for political grabs. It's a question of bringing political pressure to bear on the UK Parliament to agree to another referendum or even to skip that step and enter into negotiations for independence. And you have to see the Scottish Government's plan to treat the next UK general election as a de facto referendum. In that light, a de facto referendum, this isn't a constitutionally regulated or recognised concept. There are precedents for single issue elections. You have to go quite a long way back to find them, but there are precedents. Nevertheless, this is a political tactic. This is a way of putting pressure on the UK Parliament to come to the UK government to come to the table. Because it's a political tactic, I think it's maybe a bit of a mistake to get too worked up about the details of what matters or what counts as a mandate. I mean, the SNP and the other pro-independence parties are entirely free if they want to campaign on a single issue. They can't guarantee, of course, that the other parties or the voters will go along with it, but it might. And if they get support on that basis, they are entitled to see their view as having been endorsed. Clearly, also, I think this approach, it's suboptimal compared to a referendum. It's suboptimal for reasons of clarity over the process and the result. It's a politically risky tactic. The electorate is not all that favourable towards the independence case compared to the franchise that would apply for a referendum. So it's suboptimal, but when all that's available to you are political tactics, it is a political tactic that can be used. And of course, if it turned out that support for the SNP or the SNP plus the other pro-independence parties was sufficiently high, then all of these quibbles about what constitutes a majority and where people are really voting for independence, all that would become mere quibbles. It wouldn't really matter if support was sufficiently high. So I'm going to end at the point where I always end, which is that the most effective pathway towards independence is to ensure there is clear and consistent majority support for it, such that the case for independence becomes difficult to resist, just as the case for devolution had become difficult to resist by the late 90s because the level of public support was so high. Now that's obviously very frustrating. I recognise it's very, very frustrating. But delay is probably advantageous in some respects. Delay does give time for people to be persuaded and for the majority to be built. Obviously, the arguments timing arguments against having a second referendum become weaker the longer we move on from 2014. And of course, the demographics of independence strongly favour the pro-independence side rather than the unionist side. And that's not to say that there aren't also risks, but risk and delay, but there are some advantages. So I'll stop there. I'm sorry I don't have a more optimistic picture to paint for you. I think said that the legal situation in relation to independence could change if the Scotland Act is amended, but that is unlikely to happen anytime soon. Certainly it's not going to happen under the current UK government. Whether there's any prospect of change under Labour remains to be seen. Gordon Brown's review of the Constitution is due to report early next month, I believe. And it would be interesting to see if he says anything at all on this point. From the leaks that have been made so far, I don't think he will, but we wait and see. Thank you.
Okay,
Thanks very much. Thanks very much, Aileen. That was I really appreciate your insight there. There was a lot of technical stuff there, but it was good to get a breakdown of what the Supreme Court was actually saying in its judgment on these various issues. I do think there's although we're not going to get a referendum in October next year, I think the pathway should be fairly clear, and that we need to be out there and building support, which becomes unstoppable. So Jane, do you want to take over the question and answer session? There's quite a lot of questions come on chat, if folk can put their hand up. There's also quite a number of questions coming through from the Facebook live stream. So are you able to deal with that, Jane? That's great. Cheers. Thanks.
Yeah. Thanks, Aileen. There's some chat in the meeting chat and also in the internet. There's talk about us being a de facto colony. Does that mean we can go to the ICJ?
Okay, so 2 points to that. One, we can't go to the ICJ because there's no right of individuals petition to the International Court of Justice. Only states can take cases or UN organs. So there's no direct pathway to the ICJ. But even so, I don't think it's plausible to say that Scotland is a de facto colony. I mean, there's an important legal difference between colonies and parts of the UK, which is that if you are part of the UK, you're represented in the UK Parliament. Now, I accept, of course, that representation, because of the asymmetry of the UK, is very imbalanced. But nevertheless, there is a fundamental difference between being subject to the decisions of a Parliament that you have no say whatsoever in its deliberations versus one that you are at least formally a part of. And we have the Scottish Parliament. So we do have a high degree of internal self-determination. So I think that the de facto colony arguments are not very plausible as they stand.
Okay, thanks. We've got Pat. You've got your hand up if you want to come in. You're on mute.
Yeah. Hi, guys. Thanks very much for that, Aileen. Not being a lawyer, I took as much out of it as I could. But is there any way that, as First Minister, Nicola Sturgeon could recall all our Scottish political representation and create a convention assembly and dissolve the union?
Well, so that would be UDI, so Unilateral Declaration of Independence. UDI is not unlawful under international law. Now that might sound a little bit contradictory, because I just said there's no right to secede under international law, but a right to do something and no ban on doing something, these are different things. So there's no right to secede, but at the same time, unilateral declarations of secession are not contrary to international law. The problem with UDI is that as the ICJ has clearly recognised, there is no obligation on any other state to recognise the UDI. And independence is only effective if it's recognised by other states. So you can only become an effective independent state if other states are prepared to recognise you. So, I mean, sometimes UDIs will be effective, sometimes they will be recognised by other states, sometimes they're partially recognised, i.e. they're recognised by some but not others. In some cases, they're not recognised at all. I mean, Catalonia's UDI is obviously the big warning flag there. But even if it was even if we had a sort of partially successful UDI with partial recognition, you can pretty much guarantee that the UK would not recognise it. It took a very long time for the UK to recognise what was then Rhodesia's UDI. And that would be a problem, as our neighbour and as our biggest trading partner and all of those things, that would be a real problem. The other real problem is that we almost certainly wouldn't get back into the EU because Spain would definitely veto us. There's absolutely no doubt about that. So I think for that reason, the Scottish Government has always ruled out UDI. By whatever route you get to it, the First Minister's always ruled out UDI because she thinks it would not lead to effective independence, and I think she's right on that.
Okay, thanks, Michael, and then I've got questions here from the internet as well. But if you want to come in, Michael.
Yeah, I'll be sorry if I bore people, but I'm not a lawyer, but I did study law quite extensively, and I've got a couple of quite technical points to make. My study of law was in English law, and I'll come back to that in a second. But the first point was that if you actually read the judgment, and I sat through literally in the Supreme Court, I went down there to London, all 9 hours of the hearings and read the 34 pages of the judgment, you will find that approximately 2/3 or more of it is contained in what Aileen quite rightly dealt with in a very short period of time, which is the attempt by the UK government to have the entire case, the reference, thrown out. That was utterly hopeless and didn't succeed at all. And it was fairly obvious if you watch the videos of the hearings that the judges had little sympathy with that. But they still spent 20 pages of their judgment basically dismissing it. But it does seem to me that that was a deliberate wrecking attempt by the UK government over the reference by the Lord Advocate, which the Scottish government had decided on. And I think that wrecking tactic to an extent succeeded because very little of the judgment does focus on the substantive issue of the right of the Scottish Parliament. And my second question and point is that an entire trick was missed, or an entire issue was missed in the court judgment about the question of referenda in England. So the whole question of referenda starting with the Northern Ireland Parliament, which itself is a significant issue and was raised during the court, that whether the Northern Ireland Parliament that existed between 1922 and 1972 based on the reserve powers model that now applies, had the right to organise a referendum, which in fact they weren't able to do because they were dissolved. And the UK government then took forward their very sectarian referendum called the Northern Ireland Border Poll. The question is whether they had the right, and that was actually raised by one of the judges in the hearing, but wasn't taken any further because nobody knew much about the history of the Northern Ireland Parliament. But in relation to England and English law, we have to remember that 4 of the 5 judges in the court were trained in the English courts. Now, in England, we don't have devolution in the way that we have it in the rest of the United Kingdom. The highest tier of devolved government is local government. And in local government in England, they have the power to organise referenda. This has existed since 1972 in that a parish council was explicitly given the power to organise a referendum on any issue in what was called a parish poll in the 1972 Local Government Act. And we heard the case of Whitby Council, and a parish council in England that had a referendum earlier this year over the issue of the boundaries of local government into which it fell, but also a totally separate issue about second homes in the area, which is not actually the responsibility of local government at all, but they still were able to legally have a referendum on something over which they had no powers. But more importantly, on the same day the Scottish Parliament was elected in 2021, there was a referendum organised by 4 district councils in Somerset in England about the structure of local government. And they argued that they had the power to organise that referendum on the basis of something called the Localism Act 2011, which has within it a thing that's called a general power of competence. Now, that general power of competence is used in English local government because of the fact that it doesn't operate the reserve powers model that the UK government has applied to the Scottish, Welsh and Northern Ireland devolved legislatures. So what we now have is a situation where a parish council in England and a district or other council in England, the tier of local government directly below the Westminster Parliament, has the power to organise a referendum on anything, including housing, the borders of its boundaries, whether, whatever local issue that they decide they want, they can organise a referendum on it. But the Scottish Parliament, that is supposed to be the most powerful devolved parliament in the world, doesn't have the power to conduct a referendum on a matter that it sees. And that, to me, my mind, creates a huge anomaly in English and UK constitutional law that needs to be hammered home within the Scottish context. A parish council has the power to organise a referendum, but not the most powerful parliament in the world, devolved parliament in the world, the Scottish Parliament. And I wonder what Aileen's thoughts were about that particular issue, because it was not discussed whatsoever within the context of this court case.
Yeah, that's a really interesting point. Thanks for making it. I mean, I think what that demonstrates is maybe the weaknesses of the approach to interpretation that I said the court adopted, which is to focus on the statute. And as you said, there's express statutory power or other powers that you can interpret in the local government context or their referendums to be held, but there is a different statutory structure under the Scotland Act, where you start by thinking about what the Scottish Parliament can't do and focusing on the meaning of those statutory words, rather than thinking about it in terms of what should the Scottish Parliament ought to be able to do. And that's been a very deliberate feature of the Supreme Court's devolution jurisprudence since around about 2012. The approach was initially different. There was a very early Northern Irish case called Robinson, which was about whether the Northern Ireland Assembly had to be dissolved because they hadn't managed to agree a power sharing government within the precise statutory period set out in the Act. And in that case, the House of Lords, as it was at the time, said, well, the Northern Ireland Act is a constitution, effectively. And as a constitution, we don't interpret this in the same way as a statute. Instead, we adopt a generous and purposive interpretation. We think about what it was intended to achieve, what the purpose is, what would best serve the purposes of the Act. Now, that approach was deliberately rejected in relation to Scotland and Wales by the Supreme Court in a couple of important cases in 2012. In those cases, they said, no, we just look at this as an ordinary statute. That will be the most predictable way of resolving disputes, because if you're looking just at the words of the statute, people don't have to speculate about what values are going to be read into the decision. They also said it would be the best way of maintaining impartiality as between the UK and devolved governments. Now, that sort of worked for a while devolution was fairly stable, but since devolution ceased to be stable, and since the UK government, UK Parliament started amending the devolution statutes without consent, I mean, that approach really breaks down and really favours Westminster over the devolved. But so that's the reason. I agree with you, it's anomalous, but that's how we get into that situation, because the court is not addressing these questions in terms of what powers should these parliaments have. You know, it's not starting from first principles, but from the statutory text. The other point you made about what was the focus on the procedural issue, was that a deliberate wrecking tactic because it sucked away attention from the substance? Now, I agree with you, it did suck away attention from the substance. And I've heard other people suggesting that was significant as well. I guess my own view, maybe less cynically, was that the reason why so much time was spent on the procedural issue was because it was entirely novel, because it just hadn't come before the courts at all before. So I'm not surprised that the court was more interested in that, whereas the issue about whether a referendum bill related to a reserve matter not only applied principles which had been worked out in a number of cases previously, but also had been really well worked out in the academic literature. You know, there was lots of the arguments on both sides were really well known. So I'm not that surprised that it didn't take up so much of the court's time. But thanks for those points, both really good ones.
Okay, thanks. We've got some from the internet, and that is, first of all, why was the Supreme Court allowed to make a judgment about international law?
Well, because there was a question of international law raised before the court. So the SNP argued that that the Scotland Act had to be interpreted in the light of international law, and therefore the court has to make a decision about what international law means. So it's as simple as that.
We've got another one here, and it's kind of echoed in the meeting chat just about Scotland is outnumbered in Westminster, so how can it have any self-determination? And in the meeting chat, it's saying that as well, like, you know, if even got a section 30, if it went back to the Supreme Court, people wouldn't allow it. I think there's a bit of, people are feeling a bit down about being allowed to have another referendum.
No, I mean, I agree with that. I think it's difficult to understand a principle of self-determination that is dependent on somebody else agreeing to exercise it. However, we have precedents for the UK Parliament agreeing to the exercise of self-determination, not just in Scotland, but also in Northern Ireland. So yes, I agree from a principle point of view, it feels very odd, but it doesn't make it impossible if at the political level that right to self-determination is accepted. So I don't have a better answer than that. But as I say, I understand why people would feel pessimistic about it, but it has happened and could happen again.
We've got a question. Should we have a vote about the kingdom before we have a vote on the union? And do we have the sovereignty to do that in the first place?
A vote about the kingdom? What does that mean, a vote on the monarchy? The monarchy is reserved.
I'm presuming
that either. No, definitely reserved. And so exactly the same principles, the same arguments would apply, that even if it was just an advisory referendum on whether Scotland should be a republic, that would, on the same analysis, be regarded as relating to a reserve matter, which is the powers of the Crown. There are some exceptions, but the basic existence of the monarchy is reserved.
Mm-hmm. There's quite a lot in the chat there about people saying about having a petition. or maybe dissolving Holyrood and have an election in Holyrood. And civil disobedience. And Alana had a good one. She said, did we sign something in the past that we shouldn't have?
Well, 1707, I don't know. So there are multiple political tactics that could be considered. So it wouldn't be impossible, I don't think, to engineer a dissolution of Holyrood. If the Scottish government resigns and blocks the formation of an alternative government within 28 days, then a general election would have to be held. So you could treat that one as as a plebiscite election. I mean, but again, that has all the problems with the voters. Would the voters be willing to go along with that? Would the other parties go along with it? Would you be punished for it? And since the power to legislate for a referendum is now firmly at Westminster, you might get objections that it doesn't matter what the Scottish Parliament says anymore on this point because it's reserved. But multiple potential political avenues are available. There isn't one pathway, and there's no guaranteed pathway.
Okay, thanks. We've got a couple of hands up, but before that, there's somebody else on the internet saying, are we in effect in the same position as Catalonia?
No, because the big difference in Catalonia is that the Spanish Constitution bans secession. So they do have that constitutional barrier that we don't have. The Constitution could be amended, but amending a constitution is a more difficult thing than passing a statute, both in practical terms and psychologically. So we're not in the same position as Catalonia, and of course, the political and legal systems are completely different. All the legal actions that were taken against the Catalan government probably wouldn't apply here, although, well, I would hope they wouldn't. So I think we're not in the same position as Catalonia. We have a much more open constitutional system, and that's something that is a positive thing to bear in mind.
Okay, thanks. We've got a few hands up. We've got, I think it was Malcolm, Pat, and then Keith.
Right, Aileen, thanks again for how you're handling all these questions. But I mean, my view is that the UK saying Scotland's a prisoner, UK government saying Scotland's a prisoner is going to build support for independence. I think that's a certainty. However long it takes is down to us and how we campaign. Now, everyone's that's posting up is perfectly correct. Scotland can vote for independence, a de facto referendum. The UK government might say they're not going to recognise it, but there is a tipping point, and I think that would be a tipping point. I don't think they would necessarily just say we'll negotiate Scottish independence. What they will do at that stage is say we'll give you a referendum. That's how things are going to pan out in my view. But one thing I did wonder is rather than look at it through the right to self-determination or the right for Scotland to have a referendum, should all citizens in the UK not have the same rights? And why should citizens in Ireland, Northern Ireland, I should say, have more rights than citizens in Scotland?
Yeah, I mean, I think the position of Northern Ireland and the fact that it's ignored always is really, really interesting. If you try to raise questions of consistency with Northern Ireland, you're always kind of fobbed off with, well, Northern Ireland's different, right? And of course, it is different. It has a different political history. and a much more problematic political history, and there is the international dimension of it. And of course, their right is it's not a right to secede, it's a right to become part of the United Ireland, so it's quite a limited right. Nevertheless, there is a clear inconsistency there, and I think more could be made of that in political terms, because a lot of the things that are said about referendums in the Scottish context, the once in a generation thing, well, we're already beyond what constitutes a generation in Northern Irish terms. It's only 7 years, and we're already 8 years on from the first referendum. Arguments about the need for 60% support in the polls, or 70%, or supermajorities, all of these things, those don't apply in the Northern Irish context either. The trigger for a border poll is if it appears to the Secretary of State that a majority would vote for one, and it has been quite persuasively argued that that any border poll would be on a 50% plus one basis, and it would be unlawful, it would be a breach of the Good Friday Agreement if it were anything higher than that. So again, why is there this inconsistency that's accepted? Yes, there are differences in Northern Ireland, but why are they relevant? And that's the question. I think those questions are definitely worth continuing to ask.
Thanks.
Okay, thanks. Pat, you've got your hand up. Is that a question or an old hand you've got up?
It's a question. It's a further question. Aileen, is there a mechanism within the claim of right where the Scottish Government or the Scottish people could enact independence?
So the powers of the Scottish Parliament are limited by the Scotland Act. They don't have anything, there's no alternative source of powers that they can draw upon or refer to. So that's one point. The other point about the claim of right, so I understand the argument that's made in relation to the claim of right, that this is evidence of a right to rebellion, or that was part of pre-Union Scots law. There's certainly grounds for supporting that position in the claim of right itself, but it was a contested constitutional doctrine pre-Union. It is highly uncertain that it survived the Union. And even if it has survived the Union, as I said earlier, none of the details are worked out there. What is a right of rebellion, a residual right of rebellion for the Scottish people? How is that operationalised? Who puts it into practice? What are the trigger conditions for it? Who decides? You decide, okay. But so there's a whole load of steps that would have to be filled in that would be hugely, hugely controversial. So that I just don't think that historical material is nearly as powerful as some people think it is or hope it is.
My point would be, supplementary if I may, my point would be that in 1707, Scottish Parliament was not dissolved, it was put into abeyance. It has now been taken out of abeyance, and the laws that were pertaining to the Scottish Parliament back in 1706 to 1707 were not repealed. So they are still live. And if the Scottish people have the right, then the Scottish people can enact those laws and the rights within those laws.
Well, I mean, in legal terms, it's a highly controversial statement to say that the contemporary Scottish Parliament is just the reincarnation of the pre-Union Scottish Parliament. I mean, it's institutionally nothing like it, and its legal provenance, it is an act of the UK Parliament, not some sort of historical route. And it's also problematic to say that everything that was in existence pre-1707 somehow survives unchanged. I mean, some of it was changed by the Treaty of Union. It just was, and the Treaty of Union states that it is permanent. It doesn't contain a mechanism for its own dissolution. And we're talking about centuries ago. You know, the law, some aspects of the law have continued in force, but large parts of it, and particularly our understanding of how we should be governed and what the legitimate principles of democratic government are fundamentally different to what they were in 1707. So I think there's all sorts of technical and also principled objections to the idea that somehow we can just revive pre-1707 constitution and somehow put that into effect. I understand where your arguments are coming from, but I just don't think they're very persuasive. Sorry.
Okay, thanks. Keith, you've got a question?
Yeah, I'm just wondering, I've listened to all the legalities of the situation, or as stated by Aileen, the Northern Ireland, the differences in the Northern Ireland and Scotland, and obviously the parish council, and the largest and biggest and heaviest, if you wish, devolved government in the UK. If we don't have the powers of that parish council, if you see, where does Scotland go now to become an independent country? It appears now that we are a region of the UK, and all the Tories have to do, or Westminster, because the Labour Party is the same, is that all you have to do is, right, your question is, how does Scotland become an independent country, blah, blah, blah. I refer you to the Supreme Court decision. Where do we go from here? What do we do? Disregarding the bit about civil disobedience, because I don't really relate to that at all, because I don't wish Scotland to become something like what happened in Northern Ireland with the violence and the terrorism. So morally, we have the right to become an independent country. Where do we go from here? What do we have to do? And where do we go to become an independent country and leave the powers or the Tories behind us? What do we have to do?
Well, like I said, there is no single prescribed route by which you can guarantee that outcome. But it's not an outcome that is impossible, legally impossible to achieve. It's one that is going to have to be brought about by political pressure, political persuasion. And I don't have a better answer than that. I do understand the frustrating and inadequate answer, but I don't think there just isn't a better answer than that I can give anyway.
So we're stuck in status quo. There is no way we can become independent, and we're going to remain part of the UK and have our resources disemboweled in front of us forevermore. There's nothing we can do. Are you then saying we can devolve the Scottish government? Because there's no need for it then, is it?
No, I'm not saying any of those things. I didn't say it's impossible. I said it is possible. It's just that there is no guaranteed route to it. Ireland used to be part of the UK and it is no longer. The UK has a history of secession, not a history of secession that I think anyone would want to follow.
No.
But that does indicate is that it is possible.
How do we get there? That's what I'm asking. You're telling me that there is no pathway. So if there is no pathway, how do we get there?
You lot are the political activists, not me. You have to decide, work that out.
Yeah, I've got.
It's not a legal question.
Well, that's what I'm asking you, because I'm not a political activist. I'm just asking the question.
Yeah.
Where do we go from here?
Yeah,
and you can't answer that.
I've got another question on that from the internet as well. You know, would a Scottish movement for democracy potentially be a runner, maybe more palatable to a broader church?
I mean, possibly. I mean, these are all questions of political tactics. And as I say, I'm not, I said that right at the beginning, I'm a lawyer. I'm not a political scientist or a political activist or a political strategist. I'm not any of those things. There are multiple potential political routes through which pressure can be brought to bear and support can be built. But these are not regulated or prescribed by law. They are in the political realm.
Yeah, and laws can be changed.
Right, laws can be changed, and that's what you're trying to achieve is to change the law.
So there's quite a lot of chat. Some of it is Mike's posting some like local referenda in England. I think people are feeling a bit like Stephen's saying, call me a cynic, but I suspect the legal arguments are likely to be decided on a nod and a wink elsewhere, and it's complicated. Let's see. People are talking about the claim of right again. Yep. Just sort of chat between each other, really. Have I captured everything there, Malcolm? Can you see anything?
I think
Quite a
you've
lot.
got the gist down the chat, but I think there's quite a lot on the Facebook
Right.
that Kevin's been posting. Have you seen these? Or can you
Kevin's
access this?
messaged me them. Kevin's messaged me them. Okay. So I think that's us.
Well, so but have you the ones that Kevin messaged you? Have you not
There's a
got?
last question that just
Read
came up
them out,
there.
love.
Sorry, that's quite a good question I'd like to answer from
Uh-huh.
Christine Cairns. Could the law not also be changed by the UK to stop us ever being allowed to leave? The answer to that is no, because that's the other thing about parliamentary sovereignty. The one thing that the UK Parliament cannot do is to bind its successors. So a law saying no secession or no independence referendum ever again could be reversed in future. So that's what I mean. There is no constitutional barrier here. It's the barriers are political.
Yeah.
So, Jane, can you not access the Facebook page? Did you not get the messages from?
I got the messages from Kevin. Yeah, I've read them
Right.
out.
So there was quite a lot of questions in that. I don't think we've run through those, have we?
Yeah.
Have we? Right. Okay. Right. Fair dues. Right. Okay, right. If we've dealt all the questions, anybody, anything else they want to ask? We're going to wrap it up at past, but we'll wrap up 10 minutes early if we've finished the questions. So put your hand up if you fancy, or put it in the chat. Feeling that. Okay, right, Aileen. Well, I really appreciate that. That was really very informative, I think, and from a legal perspective, I hope folk have got a far better grasp on options or non-options than they had before they came. So we just need to get to work and make sure we all persuade folk that they should be voting to ensure we have an unstoppable majority for independence. Yeah. So I'm up for it. I'm sure all you are as well. So we'll see you in the campaign trail. I notice we do have actually a question just getting there. So you want to from Kathy. So we'll just unmute Kathy and see what she has to say, and then we'll wind up, I think. Okay.
Yep.
Right, fire ahead, Kathy. Can you unmute?
Yeah, I have unmuted. Sorry, I was just raising a round of applause, not
All right, okay.
raising my hand to ask a question.
Okay, well, round of applause, everyone.
A really informative and really good discussion. So thank you to the organisers and all participants.
Thank you very much. Much appreciated. And is that another? Well, there's a few hands going up. I'm assuming they're not all questions now, but
That's just reactions and not questions.
Yeah, and I see Michael's asked about Yes Southside. So could you maybe post a email address, or I'll tell you, I'll message you with my email address, Michael, before we wind up. But if so, or yeah, okay, I'll do that. I'll just give you my personal email address and we can keep in touch that way if that's all right. But yeah, sorry, Aileen, that was great. I much appreciate your taking time out again from your busy schedule. And thanks everybody for joining in tonight. It's really appreciated. I hope you all get something out of it. And as I said, I'll hopefully catch you in the campaign trail sometime soon. We do have another Facebook it's not Facebook. We do have another online Zoom meeting on the 18th of January. Commonweal are printing a new book, which should be out before Christmas, called Sorted, about creating an independent Scotland. And their director, one of their directors, Craig Dayell, is going to be with us on the 18th of January. So look out for that, please, because that's going to be really interesting as well. But all the best for to everyone meantime, and thanks again for coming along, and thanks to Jane for hosting and dealing with the questions so well, and thanks to Kevin for helping us stream it. Okay, all the best. Cheers.
Very much. Thanks very much.
Thank you.
Bye.